The U.S. Department of Labor recently finalized a rule that makes it more difficult for companies to classify workers as gig workers or independent contractors.
You know, it's an interesting change from the world we were living in, and it's going to be interesting to see how employers react.
Business groups are unhappy about this rule because it's going to cost them more. It's, however, very favorable for most employees. And the reason is that when you are classified as an independent contractor or as a gig worker as opposed to a W-2 or full-time employee, there are a number of rules that businesses don't have to follow. The number one being they don't have to pay you overtime. So if you are a full-time employee and you are non-exempt under the Fair Labor Standards Act, then you're entitled to get overtime pay for working over 40 hours a week. If you're a gig worker or an independent contractor, you're not entitled to overtime work. You're also usually not entitled to company benefits.
Oftentimes, the backstory is that employers seek independent contractors to avoid paying employee benefits. It's much more cost-effective for a business.
There are also tax advantages for an employer to classify you as an independent contractor. This old rule that the U.S. Department of Labor recently changed makes it much more difficult for companies to do that. And the other thing to understand is that the company can't get you to agree that you're going to be classified one way or another. So a company can't come to you and say, hey, come on, let's agree that you're an independent contractor as opposed to a full-time employee, because you are what you are under the rule. And your company can't force you to enter into an agreement to treat you as a gig worker or an independent contractor.
It's going to be interesting to see how employers react. I mean, are they going to limit the amount of work that independent contractors have, which will lead to more independent contractors? And then from the independent contractor perspective, say an independent contractor is very reliant on one specific company for their income. That is going to be directly affected here because there is a verbiage that was used, economically dependent. And so if the individual is economically dependent on the employer for their revenue, they actually are and should be considered an employee.
Now, for those workers that want to do that want to be independent contractors, it's still entirely possible. You just have to be a true independent contractor. You have your own tools. You're not economically dependent on the company. You are, in fact, an independent contractor. So overall, the new rule, a great benefit for employees, which is why you hear some business groups complaining about it, because it's going to be more out of their pocket and less out of the employee's pocket.
Clearly, this is going to start a lot of litigation. There's a lot of questions as to what defines economically dependent, and that remains to be seen, but very new, evolving very quickly, and something that we're going to be at the forefront of, no doubt.